All right, APUS government students, here we go. So I'm going to try and get through the civil liberties notes here for you. So as we started in this chapter, we talked about civil liberties in terms of we're going to look at the First, the Second, the Fourth, the Fifth, Sixth, and an Eighth Amendment. So this was just me talking about the beginning of the chapter, the different liberties that are embedded in the First Amendment and how far they go. And the biggest part of this is recognizing that it's judicial interpretation that lets us understand what these very vague terms that Madison put into the Constitution mean. And it's probably a brilliant part of what Madison did was, we can say, oh my gosh, Madison, you put in there the liberty against abridging the freedom of speech by government. What does that mean? It's so vague. Well, I think he left that for the judicial branch over time to say what that was in different instances. So here we looked at the different liberties, as I said, that we're going to be looking at throughout this chapter. As we start then, the first thing to recognize is that when the Constitution applies to us, it has to be some sort of government action, some sort of government actor that is potentially pulling or taking away that liberty. We used the joke in class in terms of you can't sue your sister or your brother for a Fourth Amendment search and seizure. It has to be the police. It has to be some sort of government official that is potentially doing that search. It has to be a principal or some sort of administrator that is infringing upon your freedom of speech in school for the Constitution to apply. Does that mean that you win? No, it doesn't. But it just means that the Constitution applies to that case. From there, we start to peel into the different liberties within the First Amendment. So, freedom of religion, the Establishment Clause. So, this was something that we talked about where we had no national religion. We have founders that saw for centuries religion tearing apart nations. And we had a lot of people that came to our country seeking religious freedom. So, we're not going to have a national religion. All right. And you can see that key understanding. Public school sponsored government may not promote prayer as this would promote religion and violate the Establishment Clause. All right. So I think I should have put in there Vitale versus or Engel versus Vitale because that's the case that ties to that. So I apologize for that. Free exercise. All right. So you can see the key understanding there. You can believe whatever you want until your practices break the laws, public policy for the most part. So you can see Wisconsin versus Yoder is the case there. The key understanding, religious beliefs and homeschooling outweigh the government's desire to educate students. So this is a case which in essence blesses the homeschooling of students. So freedom of religion, there it is. Boom. As you move on, we're going to spend a lot of time here. Freedom of speech, I love it. It's a great way for us to look at the way in which courts and lawyers think and operate within the law. So, free speech, as you can imagine, speech, it can be armbands, it can be signs, it can be t-shirts, it can be things that I say. And where I say them matters. If I say them in school as a student versus I'm out in the public thoroughfare, or if what I'm saying in terms of protesting a president versus other sorts of speech. There's all sorts of different ways in which we can do this. First, state action, as we talked about, has to be there. All right, going to be some sort of administrator, going to be some sort of police officer, going to be some sort of law that is potentially restricting speech. Then from there, you can see I'm only giving you three. There's probably 6, 7, or a dozen more now today in terms of classifying, identifying the speech. We're going to focus primarily on school speech and political speech. And as I talked about in class, you can have speech in school that's obscene, that talks about a president. Oh my gosh, Mr. P, it's all three. Well, that's going to be a part of what the courts and the attorneys are going to unravel. They're going to find a way to, in essence, pigeonhole this speech into a particular type, excuse me, because then in step 3, That is where we're going to connect the government stopping power, the ability of the government to stop that speech, legally or illegally. So don't talk to me about school speech and then talk to me about clear and present danger, because that's going to be for political speech. Just like if it's political speech, don't talk to me about disruption. Talk to me about clear and present danger. All right. So connect that speech to the ability of the government, the precedents that we looked at in terms of their ability to stop them. So if it's school speech, talk about, is there a disruption? Does the message go against the school mission? All right. And it's not so much as I talked about in class for you to say, hey, I know exactly the way in which the court's going to treat that. No, it's you understanding how to go about the process. The outcome, hey, it can go a lot of different ways depending upon lawyers and judges. All right. Just like political speech, it can go a lot of different ways, but at least you know to talk about if it's political speech, clear and present danger. Is there a clear and present danger? And you can argue that both ways. We talked about the Morse versus Frederick case. We then took some time and looked at some different freedom of speech issues. We looked at some cases. You guys acted these out in class. This was a lot of fun. Then we move on to freedom of the press. And so freedom of the press, pretty cut and dry. One case here, New York Times versus the US, the preferred position doctrine, basically giving a preference, preferred position that things be published. All right. We want to have that freedom of the press. And the only ways in which prior restraint, censorship by government of the press can happen, as this famous case with the Pentagon Papers talked about in New York Times versus the US, is if there's an ongoing threat to national security. All right. And in this case, the Pentagon Papers, the government couldn't prove that. It was things that had happened in the past. Yes, it was damning and made our executive branch and our president look poorly, but they couldn't prove that it was going to harm any troops in Vietnam. And so you saw that the newspapers won in that case. So this is kind of the standard bearer case for freedom of the press. Then we talked about selective incorporation. Just know that strangely, weirdly, over time, there have been cities and states that have drug their feet on applying the Bill of Rights to their city and state laws, right? And what selective incorporation has said is, come on, cities, states, get with it. You, just like the federal government, has to provide the Bill of Rights amendments. You don't need to memorize any of those cases. That's just showing you the big picture of over time, the application of the Bill of Rights, of those rights to cities and states over time. The big thing for us to recognize is that the selective incorporation, this process, has happened with the 14th Amendment. The 14th Amendment has been utilized to do that because it says that there at the top, no state shall make or enforce yada, 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 yada. Okay? So we're going to keep that simple, as simple as we can anyways. McDonald versus Chicago ties to that because it utilizes selective incorporation. It's an ordinance, as you can see there, that has been found to be unconstitutional. So we had state action, the city ordinance. We have McDonald, this man in Chicago that's going to sue saying it's an ordinance that's unconstitutional, that infringes upon his Second Amendment rights, that he has to have his gun disassembled at home. And so the Supreme Court finds this unconstitutional. They find this ordinance unconstitutional. And so they're going to utilize judicial review. They're going to rip up this ordinance. And selective incorporation plays into this because they say, hey, the federal government, states, the cities, you can't have laws like this. All right. So it applies to all governments. Selective incorporation is a part of it. And you can see the utilization of judicial review. Then we move on to the Fourth Amendment. All right. Fourth Amendment. All right. So on no unreasonable searches and seizures, you're going to see the police searching and seizing 9 times out of 10. It's going to be a home. It's going to be a car. So make sure that when we look at these things, These are, when can the police search without a warrant? When can the police search without a warrant? And so when it comes to a home, there's a high expectation of privacy. This is what the Supreme Court has said Madison was really geared towards, right? So if you give consent, they can search, but you don't have to give that. And really, the only other reason that they can come in without a warrant is an emergency to save a life or evidence. And we talked about in class that scenario where in Papillion, they break down a door because they hear a scream. They get a man off of a woman right in front of the door because he was beating on her. And then there's a gun, I believe, and there's some drugs there. Can that evidence come into court when they didn't enter the home with a warrant? And what the police found, excuse me, what the courts found of the police action was that it could. They didn't go in the basement. They weren't searching through drawers. It was pretty much kind of right there in the near vicinity. And what they found was, well, it was reasonable that it was pretty much right there out in front of them that that evidence could come into court. So in addition to those assault charges, you saw that defendant get charged with gun charges and with some drug charges of which he was convicted for. When it comes to vehicles, the main focus here is on plain view. All right. Can they see drug paraphernalia? Can they see a beer can in the back? Can they see something in plain view? And that more often than not is the ability to allow the police to search a vehicle. Different than a home, lower expectation of privacy with a vehicle. Tied to this then is the important thing of the exclusionary rule. The exclusionary rule gives teeth to the Fourth Amendment. If the police search illegally, that evidence has to be excluded. It cannot come into court. So that exclusionary rule is a big part of that Fourth Amendment. All right. All right. So we went through some scenarios. We talked about some things. Then we got on to here our last lecture with focusing on Miranda rights. All right. And so just like evidence, statements are evidence as well. So if the police gather evidence from a defendant without Mirandizing them, coming from this Miranda versus Arizona case, informing them of their right to silence, there are times where that evidence, those statements cannot come into court. All right. So keep that in mind as well. So when the police are talking to a suspect, they better, if they believe that they could have committed a crime, they better inform them of their Fifth Amendment rights. All right, because that's going to be one of the first things that a defense attorney is going to want to pull apart. Did you Mirandize my client? Did you remind that person of their Fifth Amendment right to silence? And that extends from that moment, from that question, until they die. They don't have to get up on the stand, so on and so forth. The Gideon versus Wainwright case ties into Miranda because it's a part of those Miranda rights. You have the right to an attorney if you can't afford one, so on and so forth. All right. So this is a case, and we talked more about this in class, where defendants have the right to an attorney, creates a public defender's office in many states throughout our country that didn't already have one. And you can see Gideon versus Wainwright utilizes that 14th Amendment, selective incorporation, to force all cities and states to provide this right. Okay? Then you saw there at the top, we're talking about charging crimes versus conviction, arrest, probable cause versus guilt. So I could be arrested for a crime. They may think that I did it. They may have enough evidence that I probably, maybe did do it or maybe not. All right. But to gain that conviction, they have to prove beyond a reasonable doubt. They have to prove. And so you can see that guilt, that higher threshold. I try to utilize a percentage, though that's not hard and fast, but just try to give you a ballpark idea, of that belief that jurors have to have when they get into a courtroom versus what the police have to have in order to arrest someone. All right, to get through this then, just to finish up the Eighth Amendment, no cruel, unusual punishments. You can pause it here and read through this. But again, we're looking at what did Madison think when he wrote these amendments? What did he mean by no cruel or unusual punishments? And the basic sense today is as I finish up, Certainly, we're going to have state action. We're going to have the military, the federal government, a state trying to put someone to death. And then what has the Supreme Court said in terms of what is and what is not cruel and unusual? So putting together all of these different cases from long periods of time, and we won't get into methods of execution, but by and large, there's a lot of methods of execution that the state can use, from the gas chamber to the electric chair to firing squad to hanging, lots of different things. But seemingly through all these cases, the Supreme Court has said a person can be put to death if they're competent, if they were 18 years of old or older when they committed the crime, and by and large, there's a homicide case. All right, you can see some of my exceptions there. Treason, terroristic acts, those are a couple of those exceptions to homicide. But by and large, someone else is going to have to die in order to put someone to death. Then on the right-hand side, we took a look at some cruel punishment exceptions. All right. You cannot kill the mentally handicapped, minors, non-homicide offenders. You see that I have the question marks there that tie back to those exceptions. And then we went further and talked about the Supreme Court has said recently within the last 10 to 15 years that furthermore, with minors, you can't just lock them up and throw away the key. You have to give them some opportunity for parole. All right. Their minds not fully developed until the mid-20s, not fully understanding or comprehending the repercussions of their actions. You have to give them some opportunity for parole. Maybe it's 20 years, maybe it's 30 years, maybe it's 40 years. You can't just take a 17-year-old and lock them up and throw away the key and say, hey, you're going to be here for the next 80 years of your life. All right. Does that mean they have to get out after that time? No, but you at least have to give them the chance for that opportunity for parole. And then we looked at some of the different methods of execution. We talked about this with that question being a great example of federalism, different states, different choices. Nebraska having the death penalty, Iowa not having the death penalty. So make sure you go through those. And that, in a nutshell, is all three lectures that I went through very quickly that deal with civil liberties. So see me if you have any questions.